All rise. Jackson County Circuit Court's now in session. Honorable Thomas D. Wilson presiding.
Please be seated.
Here's one. That's Pete. Do you want the whole files or do you just want your stuff?
Let's just keep them handy right there. Okay, what we're gonna do is we're gonna start, I'll hear from the attorneys as to any scoring issues. Once we get done with the scoring issues, as far as the guidelines go, we'll then next move on and I'll deal with each defendant individually. Gentlemen, who wants to go first?
Professional. And as to the PRVs, we object to scoring PRV 3 from Musico. We got to finish outside the gap.
I agree with you. I had already made a note and probation is aware of PRV 3 going to be scratched.
Okay, as to fiscal 4, currently scored at 10 points.
All right.
These are public safety and public ordinance crimes. There is no specific victim. The sentencing guidelines do not define who a victim is. The plain and ordinary term meaning the term victim is a person against whom the criminal act is directed. This is an indirect crime, material support of terrorism. These guys were convicted of helping somebody else prepare to commit a criminal act. Their crime is directed towards Adam Fox, Barry Croft, individuals who trained at Luther, Michigan, not at any one particular person. And that was the argument that was provided by the government at trial, that they provided facilities. Furthermore, this offense variable requires professional treatment in order to score 10 points. That there was
or anticipated professional treatment.
Or anticipated professional treatment. Oh, that's fine. But to comply with the Hardy standard, there needs to be some evidence that there was psychological injury that was significant that either required or could require professional treatment. There's been no evidence that Ms. Whitmer is seeking professional treatment for anything, and this is an offense-specific variable and a defendant-specific variable. There's no evidence that Mr. Musico did anything that required Ms. Whitmer to seek professional treatment or receive professional treatment. Furthermore, there's no evidence that she's getting professional treatment, and that is, although that factor is not determinative, it is a factor that the court should consider. I've seen the letter that she wrote. We would object to that letter being included in the sentencing package of the court file because she is not a victim of the offenses that my client has been convicted of. And based on my understanding, it's the same letter that was submitted to federal court. How do they differentiate what Mr. Musico was convicted of versus what Adam Fox is convicted of, Barry Croft is convicted of, or people of Luther, Michigan are accused of, Your Honor? You know, and there was a case in which alleged complaining witness who did not speak under oath at sentencing wrote a letter, and the court determined that it was sufficient to score 10 points as a result of that letter. And I've cited that case in my sentencing memorandum.
Right.
But in that case, that person testified under oath at trial and was cross-examined at trial by defense counsel, and the court was able to observe her demeanor. That has not happened in this case. As I indicated, OV4 is offender specific. There's no evidence that the conduct that Mr. Musico is convicted of, which was providing facilities, according to the argument advanced by the government, that providing facilities caused serious psychological injury that require or would require medical treatment. There's no evidence that Ms. Whitmer is unstable enough mentally because of the results or the actions of Mr. Musico that she either is currently seeking medical treatment or she needs to seek medical treatment and has not done so. And the court needs to look at when this offense variable was added by the legislature. The or needs medical treatment, that's for poor people, Yana. That's for people who get victimized but don't have health care and can't go get mental health treatment. They didn't want defense attorneys to be able to come to court and say, yeah, this poor person was victimized, but because they didn't get medical treatment because they can't afford it, don't score this offense variable. That don't apply for Ms. Whitmer. She's got great health care. If she was really seriously psychologically injured and needed help, she can get the help. So the court should consider that factor heavily if there's no evidence that she is currently seeking psychological treatment. That's the OB4.
Your Honor, my argument mirrors Mr. Johnson's. Right? Mr. Morrison has been charged and convicted of providing a facility, nothing more. These, as Mr. Johnson pointed out, these are, defendant-specific, offense-specific charges that deal with the public trust, not an individual victim. Therefore, to allow this letter to be added to the pre-sentence report and go forward with scoring this, I find it to be inappropriate.
And Your Honor, just briefly, I agree with Mr. Johnson. I have the same arguments, same as Mr. Ballard. I do have a couple more arguments that are specific to my client, Mr. Bellar. First of all, one of the other issues is, and I looked at this closely, when you look at, let's say OB3, for instance, it says in multiple offender cases, if one offender is assessed points for death or physical injuries, all offenders must be assessed the same thing. There's no language regarding that in OB4. Regarding the psychological injury to victims. Why is that important in my argument? This is why it's important in my argument. The court sat through this trial. There was no facts presented to this court that my client ever discussed kidnapping Governor Whitmer. There was discussions at the Vac Shack about getting an arrest warrant, not kidnapping. My client never prepared, planned, trained, or did anything regarding the kidnapping of the governor. In fact, he specifically denounced it on July 7th when he started his own group. At that hearing or at the trial, the court heard actual audio where he specifically said, we are defensive, not offensive. We're not about black bagging politicians. He denounced it. He went to training on July 11th and July 12th. When he comes back, he sends a message to Adam Fox, which I provided in my pre-sentence memorandum. On July 13th, after the last contact he had with Adam Fox, saying, here's that sheriff we were talking about. He never was a part of a discussion to kidnap the governor. He never was a part of the planning, preparation. When he left, and there's facts and evidence, when he left on July 29th was the same exact day that Adam Fox met with the informant Dan in Grand Rapids, and that's when Adam Fox came up with this idea to kidnap the governor. He had already left the state of Michigan. He wasn't a part of any conversation. So I guess the OB4, if they want to try to score it, they're somehow relationing my client's alleged training to Adam Fox, which ultimately led to this plot to kidnap the governor. My client didn't know anything about it. And that was clear throughout this entire trial, Your Honor. So to assess OB4 based upon the actions of Adam Fox, I think would be appropriate. I think it should be scored at 0. And I also echo the other arguments that Mr. Johnson made. I'm not going to repeat those because they're already in evidence, Your Honor. Or I mean, in the argument.
Who's going to respond for prosecution?
I will, Judge. Good morning. Sunitha Dadamani on behalf of the people, as well as Bill Ralston. Judge, I think there's two things here when we're talking about OB4, and I think there's two different things that they're bringing up. One is the governor of the state of Michigan a victim in this crime? And the answer is absolutely yes, because the Crime Victim Rights Act defines who a victim is. And it says that a victim is an individual who suffers direct or threatened physical, financial, or emotional harm as a result of the commission of a crime. And that's 1999 Crime Victim Rights Act, MCL 780.751. Okay, so one, she's a victim. And we know that from the facts of this case because in regards to Mr. Morrison, we have recordings that we put in, Judge, where he said, hey, there was a conversation with Adam Fox and Adam Fox, tells him, hey, are you down for kidnapping a high profile asset? This is after they have talked about the governor of the state of Michigan many times. The high profile asset is the governor. And you have Mr. Morrison saying, I'm down, right? That was August of 2020. For Mr. Musico, his plan, actually, the 3 plan of going to politicians' homes and taking the violence to their homes was Fox's ultimate plan, right? For Mr. Bellar, he was involved in several discussions about terrorism, but that this crime targeted her, Judge, and she is a victim. So that's one part of it. The second part of it, Judge, is whether you should score the points, right? And this points, we have never, Judge, told the PSI writers that we would like 10 points scored for this. The governor has never said that herself, never claimed to have psychological injury. She, submitted an impact statement when requested, and we're leaving it to the court's discretion. It was the PSI writer that made that determination that those 10 points should be scored. So we're going to leave it to the court's discretion on this OB.
Any response?
You can't have it both ways. either they're gonna come to court and as officers of the court say that the supposed victim is suffering psychological injury and ask for the 10 points, or they say that it's not in evidence. And it seems like that they're saying they're not making that assertion, so it should not be scored, Your Honor.
My response on that would be, Your Honor, when the crux of this, what started this was threats against law enforcement, not against the governor. The training that they so zeroed in on during the trial was the training of June 28th. That had nothing to do with the governor. It wasn't focused on anything political. If Mr. Fox came and engaged in training at that facility, that is where Mr. Morrison has been convicted of providing some level of facility. And that point had nothing to do with the governor. They were doing basic training, and even the training beyond that did not deal specifically with any specific politician. And again, I don't find that if we're going to have crimes of public trust, public safety, there is no victim in public trust, public safety. So to add her to it and say she is now the victim of this, she was the victim of Adam Fox. She was the victim of Barry Croft, but not of these gentlemen sitting here, and certainly not of Mr. Morrison allowing this to take place on his property.
And I would just like to, I like how the people just glossed over my argument. They didn't say my client planned, attempted, did anything regarding the governor. Wasn't around when these allegations, these statements were made in August. As court's aware, left on July 29th, there was no plan, no plot, no preparation, no nothing as it pertained to the governor.
Response?
I've said what I need to say. Thank you, Judge.
What about his argument with regard to Bellar?
Oh, Mr. Bellar? Oh, well, there was certainly talk about the governor before Mr. Bellar left. In fact, there was the circle up that we talked about and 628 at the training. He continued to train. He went to Wisconsin with them after hearing those things. He was in Wisconsin, and do we really think that Barry Croft and Adam Fox toned it down in Wisconsin? I don't think so, Judge. So
Yeah, I think you got a point. They just said they didn't ask for that officer to be scored. Ain't no reason to score. That's what she said. She said that they did not ask the probation to score those 10 points. They were leaving them.
They don't ask probation. They don't tell probation what to score and what not to score.
But that's the point of filing a sentencing memorandum, Your Honor. We asking the court what to score, what not to score.
Well, you're asking me, but
Right.
her point was that probation, not reviewing it, just thought it was appropriate to put it in there.
I understand that, Your Honor, but if they're not going to stand here as officers of the court and say that the governor is suffering from a serious psychological injury, then the court should not score the offense variable.
And Your Honor, I'm sorry.
Go ahead.
In response to the June 28th circle up, as the court recalls at the trial, how hard was it for me to finally get to the point after going through 2 different transcripts that in fact that statement about the 3 plan about kidnapping the governor happened at the end of the training on June 28th. And also facts and evidence at the end of the training on June 28th, Mr. Bellar left that group, started his own group on July 7th. He wasn't a part of any of that, Your Honor. That's why and that's the only argument they've made. I think my argument is clear. And again, that's why in relation to OB3, because at first I was like, well, wait a minute, maybe it'll score because of the actions of Adam Fox and Barry Croft, and they were convicted. My client was convicted of materially supporting Adam Fox. So that's why I looked at, there's no cases directly on point, but I would assume that the legislature, if they wanted OB4 to be assigned to any and all co-defendants, or as they say in OB3, in multiple offender cases, they would also do it in OB4. They didn't do that here. And my client did nothing towards he was not a part of the agreement or plan to kidnap the governor, Your Honor. So I believe that OB4 should be scored at 0 for my client.
Last thing, judges, it's up to the court's discretion. That's how we're leaving it, but it does not change the guidelines in this case.
Well, I don't know if I can say that the governor's suffered serious psychological injury. She obviously it's had a impact on her because now she scans the crowds for any threats. She worries about the safety of everyone that's around her now. Worries about endangering loved ones, her staff, the state police that were assigned to protect her. So it's had an impact on the governor. to say that it has risen to the level of a serious psychological injury, I think it falls just a little bit short. It's definitely had a significant impact, as it would to, I think, most anyone who was the target, as she was. But at this point, I'm going to scratch the 10 points for OB4. Hold on for a second. I need to score it. Yeah, I can use that.
Do you want the PSI?
Yeah, please. Next.
Your Honor, we'd like to object to this point of offense variable 13. Both the Department of Corrections and the people have requested 25 points. Department of Corrections, their PSI don't indicate exactly why the people are sitting in memorandum. We are objecting to this score of 25 points, and we've indicated why so in our citizen memorandum. Offense variable 13 is scored 25 points for really 2 reasons. The offense was part of a pattern of felonious criminal activity involving 3 or more crimes against a person. That's not it. These are public safety crimes, so it can't be scored under that. The only one that might be applicable is the offense was part of a pattern of felonious criminal activity directly related to causing, encouraging, listening, or forcing membership in a gang. It didn't apply here. That you score 25 points when a gang tells somebody, hey, if you want to be in our gang, go rob that liquor store, go beat up that person, and go steal this. These individuals were already members of the Wolverine Watchmen on June 28th when the sentencing offense was committed. Part 2 of that is, or communicating a threat with intent to deter, punish, or retaliate against another from withdrawing from a gang. MCL 777.43-1B. It's when you victimize somebody because they want to leave your gang, withdraw from your gang. Facts aren't evidence here. Nobody said, hey, because you're trying to leave our gang, we're going to do this to you, or you have to go commit these crimes. The mere fact that they were convicted of felony firearm, gang membership felonies, material support of terrorism for what occurred on June 28th of 2020 does not avail them to the 25-point scoring. We've had a trial. We've heard testimony. The QRFs, the protests, all that stuff was lawful, Your Honor. Those weren't crimes. The conduct that to be considered has to be criminal activity. The criminal activity occurred on one day, and that activity that occurred does not fall under any of the available scenarios to score 25 points. We asked them to be scored at 0.
Your Honor, standing on Mr. Johnson's issue, I have the same complaint, the same issue with this scoring. And I would note that the recruiting and the intake was not criminal at that time, right? It was part of their group growing, but it had nothing to do with a gang-related activity. It had nothing to do with a criminal aspect of the gang membership. As Mr. Johnson pointed out, it was not part of saying you must go do this in order to be in this gang. All you had to do was answer a couple questions. And as far as the leaving, we heard testimony at the trial when somebody wanted to leave, they just disassociated themselves and the group would cut them off from communication. So the individual acts here, the 3 separate crimes, do not meet a pattern to support the gang. The felony firearm did not support the gang. It wasn't part of this reaching to that level. Neither was the support, the material support of having this at their house. This was a one-time event, as Mr. Johnson pointed out, on the 28th of June. That's when they provided this training. And at that time, as we heard testimony, to that point, nothing criminal had taken place. So because of later actions of other individuals, you can come back and say this was a criminal issue. But at the time it was committed, there was no criminal act being taken place. They were doing training, nothing more. And nobody had brought up any level of criminal activity beyond they were doing training. And for that, I believe this.
Careful, your chair was moved. I don't want you going sitting down and thinking it's right there.
Yeah, that would have, yeah.
Yeah, that would have hurt.
Thank you. But for that reason, I think the 25 points is inappropriately scored.
Mr.
And Your
Kirkpatrick.
Honor, I would echo both arguments of Mr. Johnson and Mr. Ballard. A couple other issues. It's no shock here that this case comes from Adam Fox's plot and plan to kidnap governor. The terrorist act in this case is the plot to kidnap the governor of the state. That is the terrorist act, because the facts and evidence were when my client left the state of Michigan, he broke no laws, and he didn't. The QRFs that they talk about, the one in the Home Depot, he had broken no laws. He made some comments, stupid comments, threatening comments.
We'll get to those.
I know we will, Your Honor. But he broke no laws. Adam Fox, and that's why I'm objecting to this as far as the offense was a part of a pattern of felonious criminal activity directly related to causing, encouraging, recruiting, soliciting, or coercing membership. First of all, facts and evidence. June 14th, a phone call was made to Adam Fox, first by the Wolverine Watchman, and then later that evening by Dan the informant. At first, my client was present. Through cross-examination, it was learned my client was not present. He was not present when Adam Fox was invited to this group to train with the Wolverine Watchman. They met at the Capitol on June 18th. That's the first time my client had ever met Adam Fox. First, they tried to say my client was involved in conversations at that meeting. Come to find out through the transcripts, no, he wasn't. He wasn't involved in conversation, and he wasn't a part of the video that was shown to this court and to the jury when Adam Fox was talking about what he was talking with the reporters, and he was in his Hawaiian shirt. Next is June 20th, the Vac Shack meeting. Facts and evidence. Mr. Bellar never set up that meeting. Dan the informant did. My client went to that meeting. What happened at that meeting? Well, it took a while, Your Honor, to finally get to the bottom of it. But what happened at that meeting was not that my client was talking about taking the governor and kidnapping the governor. What happened at that meeting, after all the arguments we had and the video was actually played, is they were talking about getting a valid arrest warrant from a real judge and a real sheriff to have a real peace officer go and make an arrest. No conversation from him whatsoever regarding kidnapping the governor of Michigan or anyone, period. That's facts and evidence. June 28th, that's the first training that Adam Fox comes to Munich. My client didn't invite him. That's facts and evidence. He shows up at training. They train. First, they want to say, oh, the conversation's about kidnapping politicians. And if you're not down with going after the government, or you're not down with kidnapping politicians, you need to leave. That happened after the training, not before. They tried to claim it at trial that it was before. I had to go back to the transcripts again to show that it was actually after the training. And after that training, when those ultimatums were made, guess what? My client left the group. He left them. Then he started his own group on July 7th. And that group unequivocally was created for defensive, not offensive. It was created about not blackbagging politicians, because you heard the audio. Everyone at that meeting or that training on June 28th, they're like, did you hear what they were talking about? Did you hear about kidnapping politicians? What did my client say? Mission statement. We're not about blackbagging politicians. We're not the aggressors in this state. We are going to train defensively in case we have to defend ourselves, defend someone else, or defend the Constitution. Your Honor, that is facts and evidence. Not only is it testimony, it's audio. Then we go to the training in Wisconsin, which the court heard audio as well. After my client makes that statement, what does Dan the informant say? Well, this training in Wisconsin, there's going to be some heavy hitters there. We should keep an open mind. Your Honor, you heard that. That was played in court. My client goes to that training. Then there's no facts. Well, let's strike that. There is some facts and evidence regarding what my client did as far as training in Wisconsin. You see Mark, who works for the FBI, comes in and testifies, oh, it was Mr. Bellar that was doing the medical training. What happened when I cross-examined him? You see, Mark, you just testified 7 weeks ago at a preliminary exam regarding this case, and you said under oath you didn't know who did the medical training at that Wisconsin training. Now all of a sudden here today, it's Mr. Bellar. What other facts and evidence? The only training audios and videos that you see in July is Mr. Bellar training. Training with whom? Training with the group that he created on July 7th, who was going to defensive. And oh, by the way, at least one or two of those individuals in that training video that was showed to the court were found not guilty of conspiring to kidnap the governor at federal court. We couldn't get that in, Your Honor. The jury didn't hear that, but that's the fact. And then there's an audio. There's an audio of Mr. Bellar training medical at the training. And what is it? It's him saying, make sure your medics are aware if you have any allergies or any, if you're allergic to something. You hear Adam Fox talk. He's not talking to Mr. Bellar. He's talking to informant Dan. There's no facts and evidence of what training he did. And more importantly than that, and I attach it to my pre-sentence memorandum, after this training, well, at the training, there's also conversations at a dinner table about politicians and weapons of mass destruction. My client's not involved in any of that. He's at the end of the table eating and having a drink. Provided in my pre-sentence memorandum, the email or the message, I know I talked about it earlier, on July 13th, he sends a message to Adam Fox. That's the only message he sends to him other than the one on July 7th when he says he's leaving the group. And he says, Sheriff Abbott, Dan Abbott, that's the sheriff that you need to reach out to. In his mind, they're still talking about getting an arrest warrant. They're not talking about kidnapping. He didn't say, hey, Adam, that training was great. We're switching gears now. And more importantly, Your Honor, on July 29th, and this is why I put this in my pre-sentence memorandum as well, while Mr. Bellar is letting the group know, not Adam Fox, not Barry Croft, when he's letting his new group know, hey guys, I'm out of here. I'm going back to South Carolina. I'm gonna go back to school. I'm gonna get my EMS. I'm gonna become a firefighter. Take care. He leaves the state. When that's going on across the state is informant Dan meeting with Adam Fox. And that's when the plan changes from the Capitol to the governor. My client's not involved in that.
Mr. Kirkpatrick.
Yes, Your Honor.
When he went down there, wasn't he discussing setting up his own group down there?
Yeah, he was talking about setting up a group to train, but not, Your Honor, not to go out and kidnap. Listen, Your Honor, I'm sorry, I didn't mean to say that. That was rude, and I apologize to the court for saying, listen. If Mr. Bellar wanted to be a part of the kidnapping of the governor, he would have stayed here. He would not have left. He would have went right in with Adam Fox. You heard the testimony of him being evicted. There was a moratorium on evictions. He could have held on like a rock, like a tick in that apartment. He chose to leave. If he wanted to be a part of this, he would have stayed here and he would have been a part of it. He didn't even know what was going on. He wasn't a part of any of the conversations. And that's further illustrated, well, number one, with Exhibit 177 of the people when they tried to say he was involved in the fuck around, find out chat. That wasn't true. They put that up there and said he was an administrator. And yet we had to go through all of the messages to show that he never even one time was on there. Still trying to get the connection. And then he sent the warning. I'm sure the court's going to talk about that at sentencing. When the court does a sentence, he sent the warning to his group, not Adam Fox, not Barry Croft. And he said that you guys need to lay low. The police have been poking around the house. But what does he say at the end? Which conveniently the prosecution didn't even want to present to the jury, but I did. You're right. We've done nothing wrong. We haven't broken any laws. Because in his mind, he has no idea that the plot has now become a plan, that there's training going on, that they're going up north, that they're surveying bridges, that they're surveying the governor's house, that they're doing all these things that he wasn't a part of and he had no knowledge of. So I agree with Mr. Johnson. The June 28th is the main event in this case, but it's what my client did afterwards that's important. He left. He left that group. He started his own. I don't think OB 13 should be scored at 25 points, Your Honor.
I got a question for you.
Yes, Your Honor.
He didn't think he'd done anything wrong. Why is he calling back up here saying, hey, you better lay low?
For the same reason that when he sent that message to his sister and he made another comment to somebody else about being on somebody's list for the things that he was saying inappropriate things. That's why. They were saying inappropriate things. They weren't doing inappropriate things. They never acted. He never acted on anything that he said. Yes, and we're going to get into that in allocution. He made a lot of comments that are threatening in nature and that are inappropriate. That's not what he's on trial for, Your Honor. That's not what he's being sentenced here today for. He's being sentenced for materially supporting a terrorist act. The terrorist act being the kidnapping of Governor Whitmer. And I'm asking the court to fashion a sentence here in a minute, my allocution, which I've pretty much done most of it already, based upon his actions that he did regarding the plan to kidnap the governor. Not the things he said in the Home Depot parking lot, not the things that he said at the 2 QRFs, the one in Detroit and the one in Flint, when in fact, there's also testimony. We had FBI agents and law enforcement watching them for hours. They'd done nothing. What did the officer from Flint say? I think one of us asked, it wasn't me, I think it may be Mr. Johnson. Well, did you go up and make contact with him? Did you go up and talk to him? We didn't have a legal basis to go make contact with him. We didn't have a legal basis to go up and talk to him. That was his testimony. That was the officer's testimony, because they didn't, because they broke no laws.
Adamani?
Thank you, Judge. I'm going to address the technical aspects of OV 13 by reading from page 131 of the sentencing guideline book. I'm not going to address, whether the verdict even happened or not, or the facts yet, Judge. OV 13, the second block there, 25 points, Judge. The offense was part of a pattern of felonious criminal activity directly related to causing, encouraging, recruiting, soliciting, or coercing membership in a gang. And then the second part of that, there's an or between those two. So what we're saying, Judge, is that the first half applies. And the criminal activity that's there in the book, Judge, on the page, is the whole criminal design of this gang. It had a criminal design to it. And the conspiracy started when the gang was formed, which the court knows because the court had to rule on co-conspirator statements in this case. And the court ruled that everything that came in from the formation of the gang was a conspiracy. So the criminal activity we're talking about, this gang was created to conspire for terrorism, recruit, encourage, and solicit membership in a gang, which squarely fits within this OV. Now, in the very first bullet point in the explanation section here, Judge, in scoring OV 13, all crimes within a 5-year period, including the sentencing offense, must be counted without regard to whether the offense resulted in a conviction. And here, the jury convicted on all 3 of these counts. So all 3 are included, and 25 points is properly scored.
And this one, Ms. Dadamani, I agree with you. The 25 points are going to stand.
Thank you, Judge.
Next.
Yeah, I object to scoring OV 14 as Mr. Musico as being a leader of this criminal group. The OV 14 in the case law, when you have multiple offender situations, and by offender, the people charged with the crime. There can be more than one leader. We concede that the case law says that, but there's no evidence that my client gave any instruction or direction or orders to any other offender. He was not in the leadership chat. He was not in the vetting chat. He did not set up the training on June 28th. And that is the sentencing offense, June 28th. He did not order the informant or anybody else to train Adam Fox or to provide any material support to Adam Fox. He was a original member, but he was a rank and file member. He did not give any instruction, direction, or orders to any other member of the group that was following to make him a leader. We'd ask to be scored at 0 points for Mr. Musico.
Response?
Judge, Mr. Musico is a leader. You see the chart that we put into evidence. I'm just going to put it for the record. Got the number. It's number 9, Judge. We put this in, and it shows that there were so many members of this gang going in and out of this gang. And who's at the top of that gang, Judge? It's Mr. Musico, it's Mr. Morrison, and Mr. Bellar. Granted, not all of these people were charged. Some of them were. But, Judge, they were the top. And the reason they were the top, and the reason that the jury found that they provided material support, is because Mr. Musico, living at the house with Mr. Morrison, two peas in a pod doing everything together, living together, working together, related to each other. They exchanged information. They exchanged information about this group all the time. We put in exhibit after exhibit after exhibit where Mr. Morrison would get information and he would give it to Musico, and then that information would go somewhere because they were tied at the hip. They were joined at the hip, sorry. And, not only did he live at that house and provide that as a facility for the training that occurred, he also, we had testimony from Dan who said that Mr. Morrison told him that Pete didn't need to be in the leadership chats. And the reason he didn't is because he was an advisor to Morrison and the group. And then we had pieces of evidence that came in where Mr. Musico, in his own words, recorded, is saying, I planted the seed for this group in Joe's head. I told him, this is for the younger generation. You guys take this idea and run with it. I set it up just like gangs when I was a kid, because I used to run with gangbangers. And when I call for a meeting, I got 20 guys here, I got 20 guys there. And when I call for a meeting, everybody brings their people and they come. So he was a leader in this gang, Judge.
That recording was BS. There's no evidence that Mr. Musico was ever in a gang that had 40 people under him. That's one of the problems with this whole case, and we did lose, okay? But one of the issues in this case was the generational gaps between social media users and internet users in the court system. As we say in this generation, everything he said was cap. It was false. And people don't always tell the truth on social media. The evidence is that Mr. Musico, and again, citing People v. Gibbs, 299 Mich. App 473, 2013. Yes, he's a co-defendant. He's here, he's convicted. But as a co-defendant, did he give orders, instruction, directions to other people? Exchanging information doesn't mean that he's giving people orders. There could be, in a multiple offender situation, yes, there could be more than one leader, or there could be no leader. There could be nobody who sat above the other people and said, you go do this, you go do that, you go do that. If I'm in a gang and I tell people we are going to go rob the Greenwood Party Store, I am a leader. Not just, even if I'm just a shot caller in the gang or a lower member of the gang for the sentencing offense, I led. How did he lead for the sentencing offense? He didn't. Case in point, to show he's not a leader. Originally, they didn't want Adam Fox at the Munich property. FBI agent Dan vouched for him and pushed it through. If Mr. Musico was so much of a leader, how did Adam Fox wind up at the property? Nobody listened to him. We asked him to be scored at 0.
Just one more thing, Judge. We had a recording that we put into evidence. I don't have the exhibit number on me right now, where Mr. Musico is recorded saying 60 to 70% of the ideas of the things the Wolverine Watchmen have gone through were my idea.
That is true, Your Honor. We stipulated that. He also said his house was rigged with explosives and C4. Was that true? He also said he had grenades. Was that true? It wasn't true. And those weren't elements. And Mr. Rossi did an excellent job in his closing argument saying, hey, we don't have to prove everything beyond a reasonable doubt, just the sentencing offenses. Those things weren't sentencing offenses. That was just stuff that he said, running his mouth, try to be something he wasn't, just like his house was rigged with all his explosives that was determined to be fake. He didn't always tell the truth.
Well, at that point, if I recall correctly, he said he had block of C4. I believe somebody else may have seen it. I don't know on that particular point. He also indicated he had set up propane canisters throughout the house so that he could shoot those propane canisters and they would act as an IED.
None of that was true.
Okay. Any response?
No, thank you, Judge.
Well, he was a founding member of he and Joe Morrison were the founding members of the Wolverine Watchmen. They had a goal of uniting anti-government individuals and using whatever means they could to ultimately overthrow government. Point stand. Next.
Your Honor, I have no additional point challenges in regards to Mr. Morrison.
Your Honor, just one for purposes of the record. I I doubt the court's going to rule in my favor, but I at least need to preserve this for
Yeah,
appellate review.
absolutely.
OB 20 is currently scored at 25 points. There's really no case law on this because I think this particular charge is relatively not new, but not really highly litigated.
Not used very often.
Yes. And so there's nothing that I see in the statute because what it says right now is the offender supported an act of terrorism, a terrorist or a terrorist organization. There's nothing really that I saw in the statute, which I think should be in the statute, is that there should be some knowledge that the person is in fact supporting an act of terrorism. And I'm not going to go back through the 15-minute argument I just made. I would just ask for the appellate court that they incorporate that argument that I just made regarding my client's involvement or lack thereof in the actual crime here, which is the plot or plan to kidnap the governor, which I think the record is clear. I think it's going to be clear at the appellate level that my client, in fact, did not know about any of that. He didn't. And so I think there should be some knowledge that my client knows that he is supporting an act of terrorism. Now, I know the prosecutor is going to stand up here in a minute and say, well, he trained Adam Fox and he knew Adam Fox was a terrorist and a bad guy. Well, he also said Adam Fox was crazy. He also left on June 28th and left the Wolverine Watchman. And he also denounced Adam Fox when Adam Fox asked him to swear allegiance to his group, the 3 Percenters. He said no. So I am making the argument. I do not believe that 25 points should score. However, I have no case law to present to this court today that would support that position, that there should be some knowledge that in fact what they are supporting is in fact a terrorist act. So that's my record, Your Honor.
Okay. Well, I assume both of you want to join in that argument?
No, Your Honor.
Okay,
May I respond to it?
in a second.
Sure.
Mr. Ballard,
Your Honor, I understand Mr. Kirkpatrick's argument. I guess I would log the same objection to it for appellate record only. As I said earlier, I did not have any more valid challenges I felt at that time. So I will put it simply for record purposes only.
and as I recall, I obviously didn't go through every page of this in preparation for this. I went through a number of notes. But the comment you're referencing was made after they were at the back shack. And it was outside. He said, Adam Fox, that boy is crazy. Now that could be interpreted as two ways. He's literally crazy and I want to stay the hell away from him. Or this dude's crazy. We're gonna get stuff done.
Well, and my argument, may I, Your Honor?
Yeah, absolutely.
My argument to that is, then why was it at trial that the people, through the FBI agent, said, did Mr. Bellar ever say that Adam Fox was crazy? What did the FBI agent say? No. How long did it take for me to have to go through the transcripts to, in fact, confirm that, in fact, Mr. Bellar did say he was crazy? That further solidifies, in my opinion, Your Honor, with all due respect, my argument. They didn't want the jury to hear that Mr. Bellar thought he was crazy. If they thought that his whole reasoning for saying that Adam Fox was crazy is because, well, that guy's crazy, sweet, he's down, let's get with him. No, they didn't want that. If that were the case, they'd have been all over that. Hey, when he left, he said, Adam Fox is crazy. That guy, man, we need to get behind him because he wants to do all kinds of crazy things. The court heard how long it took for me to finally get the correct answer out of the FBI agent on that issue, Your Honor.
Okay. Response.
Just on that last point too, Judge, and I have a couple things on the OV. You know how you know that it wasn't that Paul Bellar was thinking he was mentally ill, crazy? It's because the testimony from the stand was that Dan told us that, and Agent Impola told us that Paul Bellar was recorded calling Adam Fox a Leroy Jenkins. Do you remember what that means from the trial, Judge? That video game viral thing that went around where they're all stacking up against a door and the one guy, they're all planning, and then the one guy, the Leroy Jenkins character, charges in and gets everybody killed. That's how Paul Bellar interpreted crazy for Adam Fox. But regarding the obvious judge and the statute, the charge isn't new. The charge was, this anti-terrorism law in Michigan is very unique, and it was passed in 2002 after 9/11. When this country was united against the idea of terrorism and knew exactly what terrorism was and could agree on it. So this is not a new law, but it doesn't have a ton of interpretation by the appellate courts. But what the appellate courts are going to be very clear about in this case is that the defendant had knowledge in order to score these points, because that's what the jury told us. That's what the jury decided. The jury decided that the defendant had knowledge and provided the material support. So these are correctly scored.
Your Honor, may I have just 1 second?
Absolutely, go ahead.
Well, the Leroy Jenkins further solidifies my argument that he was crazy. And what else further solidifies my argument that he thought he was crazy is because on June 20th, he didn't know that Adam Fox was being invited to Munich for training on June 28th. And on June 28th, when he went to that training, at the conclusion, when Adam Fox was making his comments about things that he wanted to do, and when there was that discussion of the 3 plan, Mr. Bellar left the group. He adhered to the ultimatum. The ultimatum is you're either down or you leave. He left. And again, July 7th, the court, I'm not going to go back into all that stuff again. And there was that training in Wisconsin where there's no facts and evidence that Mr. Bellar specifically trained Mr. Fox at all, other than the allegation that he trained some medical. And then he's gone. I also provided to the court my exhibit, I think it was 2, with the connection of the other co-defendants in this case. There's none regarding my client. There's no Facebook connections. There's no meetings. There's no dinners. There's no getting togethers. There's no nothing with my client. And so, yes, on the 20th, he says he's crazy. On the 28th is the first time that he goes to training with them. And afterwards, he starts talking about actually kidnapping people, and he leaves. That's why I believe when he said he was crazy, he meant he was crazy and he wasn't about what he was about. If Mr. Bellar wanted to stay with Adam Fox, he could have stayed with him. If Mr. Bellar wanted to go up north, he could have went up north. If Mr. Bellar wanted to be included in this plot or plan to kidnap the governor, he could have done that. And he could have did the bridge surveillances, and he could have been a part of getting the layout of the governor's home or vacation home. And he could have been a part of the conversations of getting explosives. And he could have been a part of the training specific to this. He wasn't. He was gone. He left the state forever.
Anything?
Judge, you heard testimony about why he left the state, and it wasn't because he was scared of Adam Fox, because he got in some fight over a female he was dating with Joe Morrison, started his own group. That's all.
25 points, Stan. Ready to get to sentencing?
Yes, sir, Your Honor. The court has heard me make this argument before. Our biggest problem with the Michigan System Guidelines is one, they're all aggravated factors. There's no mitigating factors included in the System Guidelines. That's one of the things that are unique to Michigan. 2, as the governor's already argued, they're redundant. Okay, here in this case, my client's been convicted of nonviolent conduct, organized gang activity, crime, and physical terrorism. But in the sentencing guidelines, he gets 25 points for committing crimes while being in the gang, which is a sentencing offense, and he gets 25 points for supporting the Terrorism Act, which is a sentencing offense. Class B offenses, you go from Class A, B, C, D, all the way down to what, H. So he's been convicted of offenses that the legislature determined to be more serious than 2nd-degree criminal sexual conduct, 3rd-degree criminal sexual conduct, 4th-degree criminal sexual conduct, bank robbery. I mean, the list of violent offenses that are Class B or lower is lengthy. So applying that redundancy, his guideline range is now 26 months higher than it would be if we didn't score redundant conduct. If we didn't score redundant conduct, his guideline range, I believe, would be 21, 24 to 40. Because we scored redundant conduct, his guideline range is 51 to 85. So he's got a 26-month increase because we're scoring redundant conduct, on top of the fact that the felony firearm 24 months has to be consecutive to any other sentence. Mr. Musico's his needs assessment as scored by the probation department, probably one of the better ones I've ever seen particularly for a Class B offense. They look at 11 major factors in his needs assessment. 8 of the 11 factors, unlikely. Criminal association with peers, unlikely. Criminal opportunity, unlikely. Does his leisure and recreation cause a opportunity for crime? Unlikely. Social isolation, unlikely. Substance abuse, unlikely. Criminal probability and cognitive behavior are both scored as probable, and I believe they scored that because of purely his association with the Wolverine Watchmen. And I remind the court that his association with the Wolverine Watchmen, in terms of crimes, he never left his home. He's convicted of a crime that occurred at his home. He left his house for the protests and everything else. Those things were legal, they were lawful, and he followed all instructions. Family criminality, unlikely. They scored that unlikely, even though the son-in-law he lives with is sitting next to him in his courtroom. That's how strong and law-abiding the family structure is that he comes from. Vocational education, highly probable. Mr. Musico has a temporary education. We've been here long enough to know that somebody with temporary education is probably going to find themselves before a criminal judge a couple times in their life, right? But as an adult, for Mr. Musico, that has not been true. He has been able to keep himself gainfully employed and keep himself out of trouble, except for this instant offense. Residential instability, unlikely. Social environment, unlikely. All those factors, the Michigan Department of Corrections have said at this point, it is unlikely that will cause a recidivism. Reassess upon, incarceration, after incarceration. But as of now, the objective scientific factors that the state pays to put in these pre-sentence investigation reports say, hey, this guy is not likely to commit another offense, to reoffend. And it is likely that this guy, once he's paroled, he's going to have a stable home environment to go into so he can reintegrate into society. And all those things, I believe, the fact that he has been married for so long, the fact that he has been gainfully employed for so long, the fact that he's, as an adult, has kept himself out of trouble, the fact that he has a residence, an actual home to go to, not transient, all those things should be statutory mitigating factors in the sentencing guidelines, but are not. Mr. Musico is a First and Second Amendment absolute. I don't think there's anything wrong with that. And I think the evidence that the court saw shows that. Okay. He got himself highly passionate in 2020 over one, banning of bump stocks, which I don't think was a radical belief. I mean, how many people really turned in their bump stocks after they were banned by the Trump administration? 2, the stay-at-home orders. We had an unprecedented situation where a executive issued over 180 executive orders without bicameralization. He thought that was unconstitutional. He got a temporary education. It took the people at the Supreme Court 10 months to say that's unconstitutional. He did it in a matter of hours. It made him upset. He said some things, he posted some things. Some of the things he posted, I've seen. That governor's address about the vacation or the graduation party for, I believe it was her niece, that she was having after the stay-at-home order, that came to my phone. He didn't make that. He didn't find her address. It was distributed upon social media. And again, when you buy a home, address is a public record. People don't like it, but it is what it is. It's a public record. When he went to protest, he followed the rules. He followed the law. He didn't do anything, never pointed his rifle or his weapon at any law enforcement or otherwise. Yes, he wanted to arrest the governor. His thought process was logical. A governor took action that was unconstitutional. He thought, did she do this for her own personal gain? Did she do this to strengthen her position as a potential VP candidate? That was a logical belief system for him to make. People make those analysis all the time. If her last name was Trump, we'd have been hearing about that every day. Is she doing this because she's trying to strengthen her position as a VP candidate? What he can't do and what he's been convicted of is materially supporting terrorism. Okay? Now, I'd ask the court to, and we had the trial, the court heard the facts. He spent in the presence of my father. Jackson. He didn't go to the fact check meeting. He didn't go to any of the meetings in Dublin, Ohio. He didn't go to any of the Luther trainings. He didn't go to Wisconsin. He didn't do any of that. And he was specifically excluded from the chat groups in which that stuff was talked about. Mr. Musico, who never left his home during the course of the criminal conduct, is not a continuing danger to society. This was a highly emotional time for him. Unfortunately, it's one of the things that we talked about. All the people, lawyers, judges, and I think if my notes are correct, 8 of the 12 jurors who decided this case never missed a paycheck during those stay-at-home orders. Couldn't really put themselves into Mr. Musico's position. I've seen people since it's been random. They keep putting that picture of those guys at the state capitol with those firearms. And and I have permission to talk about this. I mean, when we first talked about it, we talked about back in May of '67 when the Black Panthers walked into the state capitol of California, and what happened to all those guys. And we knew it was highly likely that we'd be in this position after he engaged in it. People don't like that. The point of the Second Amendment is because when you protest, if you don't have a gun, nobody will listen to you. But if you protest with a gun, you will get yourself in trouble. But he didn't do anything with that. He is not a danger. He is not a danger to society. He is not a danger to any political figure. And I think a sentence of the guidelines start at 51 months. I think a sentence of 60 months plus 2 for the felony firearm is sufficient. It's a sufficient punishment for somebody who never left Jackson for a criminal offense. There's no need to run the gang crime consecutive to the material support of terrorism. Going back to our redundant sentencing guidelines, his guidelines jumped 24 months simply because he had the other conviction. He got 10 points in his PRB scoring. That took him from what should have been 0 to 10. So instead of a position where he'd be, if he had 0 PRB, his minimum would again be 24 months. His PRB level would be 0 points A. It's now C simply because he got convicted of another offense. And mind you, to go from A to B is only 1 point. To go from B to C is only 8 points. Now to go from C to D, we're talking about 14 points. And then going up to E, I think it's 24 points. So it doesn't take much to get you from A to C, to get you in that position where you're looking at substantial increase in time. So he's already receiving a significant extra punishment for the multitude of crimes that he's getting, right? He's going to get 4 additional years, a mandatory 2 for the felony firearm, and then a discretionary 2 under the guidelines, because now his guidelines are 24. Minimum is 24 months higher than it would be had he not had those extra offenses. You've seen, the family support that he has. It's outlined in the PSI. What he did was wrong, but again, he never left Jackson. He didn't go to Luther. He didn't go to Antrim County to this vacation home. Ty Garbin did. Ty Garbin was eating turkey, macaroni, and cheese on Thanksgiving, and will be spending Christmas with his family because he only went in for 2 years. Did Ty Garbin become less of a danger once he started snitching? No, he was still the same person. He would just tell. That didn't make him less of a danger to the community. So we know 2 years is a sufficient punishment to make sure these people are no longer a danger to the community. He won't get 2 years because, he didn't cooperate. He's going to do more time than Ty Garbin, who was searching for places to put bombs. He's going to do more time than the original agent in charge of the case, who split his wife's head open after bouncing it off a nightstand. Just think about that. He's going to do more time than somebody that was over there that actually committed a violent act. So we'd ask the court for the felony firearm, 24 months plus 60, the 60 to run concurrent for both counts.
Mr. Musico, anything you want to say?
Your Honor, I'm married for 26 years. At the time in my life that this is all taking place, there's a lot of emotions going on throughout the entire country. on both political sides. You had Maxine Waters talking on national television to hunt down people and run them out of their restaurants and stuff like that. Your Honor, I had a lapse in judgment. I've been a good citizen. I've been a family man. I've taken care of my family for a very long time. My wife has health conditions. I have health conditions. And I throw myself at the mercy of the court that she don't sentence me to what could possibly be life. I have emphysema I was diagnosed with in 9, almost 10 years ago. That has not gotten better. All I can do is say, Your Honor, please, I throw myself at the mercy of the court.
Comments?
Were you going to allow me to speak at the end of all three,
I'm going to have you speak after each one.
after each one, Judge? Okay.
Because
Then
I'm going to sentence them individually.
Okay, got it. So at that point, Judge, then can we have the victim impact statement, please? And then my comments, I think, can apply to all three of the defendants. And so if we could play that right now, and then I'll sit down. It's only 3 minutes.
Yeah, go ahead.
Thank you, Judge. Okay.
Hey, again, just for the record, we object to this.
I know you do.
I think the whole purpose of that.
I already said I know you do.
All right.
And that I'm going to put that objection to all three of you. Thank you.
Thank you, Your Honor.
Sorry, Judge. We didn't start it up yet, so we just have a minute where it needs to start up. Judge, we're asking to have our victim impact statement played at this time.
Thank you for the opportunity to speak with you today. It's not easy to turn the conflicting views of 10 million strong, passionate people into a government that perfectly represents them. But that is what our Constitution is for. We have elections because we must find a way to get things done while disagreeing in good faith about the issues that affect our lives. We debate and then we vote. Like all Michiganders, these three defendants are free to disagree, vote, or campaign against me. Instead, they took a different path. They supported a violent conspiracy and provided material support for terrorism. They chose actions that are antithetical to what makes our nation strong and safe. I'm asked all the time what being the target of this conspiracy has done to me and to my family. I want my family to know that their mom, their wife, their daughter, their sister is tough and stands up for what she believes in. But I cannot tell them honestly that I am unfazed. I now scan crowds for threats. I think carefully about the last thing I say to people when we part. I worry about the safety of everyone near me when I'm in public. And I'm reluctant to share too much because I worry that it could endanger a loved one, a staff member, a police officer on my security detail. I am changed, and my family has changed. Ultimately, this isn't about me, though. A conspiracy to kidnap and kill a sitting governor of the state of Michigan is a threat to democracy itself. And this kind of violent extremism has become disturbingly common. Online radicalization is spiraling into real-life action. Political leaders and their families on both sides of the aisle are being threatened and attacked. I'm thinking of Paul Pelosi, my friend, Congressman Fred Upton, poll workers in Detroit, judges who have faced violent threats, and so many hardworking public servants. Many have left office or quit their jobs to protect their families. Aspiring elected officials are turning away from the job, worried that fighting for what they believe in could make them a target. If we're not vigilant, this trend will accelerate. It could be our future. Unfortunately, these defendants have not accepted responsibility for their actions. If you want my advice about what to do with men like this, it's simple. Impose a sentence that meets the gravity of the damage they have done to our democracy. Prove that our system is stronger than plots hatched in basements. Show the people that public service is a worthy cause and that we are united in our mission to make Michigan a better place for future generations. This sentencing, however, will not be enough on its own to protect our constitutional order. The work to repair our fraying bonds will be slow and steady. It may take years, but we owe it to our children and their children's children to try. Today, I urge you to send a powerful signal about what we stand for as decent human beings, as Michiganders, and as patriotic Americans. Thank you.
Further comments?
Thank you, Judge. Yeah, I have some, and I, kind of put them all together into one sort of running thing. So I'm just going to say these once and then adopt them for both defendants, unless there's something additional that either of the defendants or their attorneys say that I need to address.
Okay.
So I think, Judge, the thing that catches my attention the most is about this case, the thing that stands out the most is just how really difficult it is for anyone at this point to agree on anything. We're super polarized, but it only took 5 hours for this Jackson County jury of 12 impartial citizens to send a super clear message. It's very simple. The defendants helped a terrorist, that they used their gang to do it, and they possessed firearms when they did. They agreed on that. We're going to ask, Judge, for the top third of the guidelines on each count imposed consecutively. So the people, just to be clear, are asking this court to impose consecutive sentencing and stack time for these charges. We do not ask this lightly, Judge.
What are you asking for?
We're asking for the top third of the guidelines and leave that to the court's discretion to be stacked consecutively. And we know, Judge, that the courts favor consecutive sentencing, but we don't believe it's appropriate, or I'm sorry, concurrent sentencing, but we don't believe that it's appropriate in this case, because for a case of this nature and magnitude, we think it's incumbent on the court to send a clear message. And I want to tell the court why. And if there was any case, Judge, where consecutive sentencing should apply, it's this case. Because terrorism or acts of terrorism are a way to short circuit democracy. It replaces public discourse with intimidation and fear to attack democratic institutions. It's not just simply like a one-on-one individual crime, Judge. It's not, one crime that happens against one individual. It's a crime where somebody uses violence or threats of violence that are dangerous to human life, like the statute says, like the statute defines, to affect the conduct of government. It's violence to prove a political point. And it's extremely effective because the threat of future violence, it works. And it works when you look at society and you see what's going on in the news and you think about the terror that people feel when there is a mass shooting at a school or a grocery store, when they think about when they want to send their kids on a trip to our capital in Lansing, but they worry and they don't feel safe sending them because what happened at the protests in 2020, stuff that these defendants were involved in. It's terrorism, Judge, is a messaging crime. And it's a message. The message is that you, the people of this country, are not safe anywhere. At any time, at any location that you go to, you could be killed by fellow Americans who are looking to prove a political point. And it's absolutely poisonous. It's extremely successful in impacting our lives, though. And the goal of terrorism is not just that, it's also to inspire others, right? I want to remind the court about the course of this trial. We presented all of these exhibits after exhibit after exhibit, where these 3 defendants were inspired and admired terrorists like Al-Qaeda, the Taliban, and the Oklahoma City bomber, Timothy McVeigh. When a terrorist goes and executes an actual mass casualty event, they show people the lengths they're willing to go to, inspiration. And then other disaffected young men, Judge, they go out and they're inspired by that. And all you have to do is look at like the streaming of a mass shooting or a manifesto that a shooter leaves behind to see how they were inspired and how they intend to inspire others. So many shootings in this country, Judge, these mass shootings that happen are committed by what society calls lone wolves, right? But what we don't talk often enough about is that sometimes there is an entire pack behind that wolf that encourages and helps that wolf. A pack that brings, just like Wolverine Watchmen wanted to, like-minded individuals into online spaces, right? Nurtures their hatred, fuels their desire to go on a rampage. And that's what the Wolverine Watchmen, all three of these defendants, that was their goal, is to be that pack. You know, these extremist factions or extremists, they're inspired to affect political change through violence because they don't have any other means of doing it. They don't have popular support, they don't have resources, they're not willing to follow the guidelines of society, you know, to change society by voting for change. So when the defense says, and I know they will continue probably to say this because they've said this in their sentencing memo, and Judge, I'd ask the court to incorporate my sentencing memo in here too. When the defense gets up here, and I'm sure they will, and I've already heard it, nothing really happened here. That's what I expect them to say. That's what they've already said. Nothing really happened here. The act of terrorism, it was never carried out, right? I ask this court to remember that terrorism works without the violence being carried out. It works when there's a threat of using violence. And why does it do that? Because the threat of violence is just as impactful. It keeps good, qualified candidates from running for public office. It makes legislators think twice about whether to vote for certain measures because they fear the repercussions from an extremist element in their base. And I don't believe any three of these defendants that are going to be here before you today and make their remarks still are going to change their anti-government ideology because it's who they are. Exhibit after exhibit, we presented it. It's who they are. It's their core identity. And in fact, incarceration by the government for crimes they don't even think that they committed is probably their worst nightmare. You know, it's come true. It validates the conspiracy theories that have been marinating in their heads for years. But it's time, I believe, Judge, in this sentence, by the courts, society, not to fear them. Because it is time to hold them accountable with lengthy prison sentences. Because terrorism's goal is to engender fear. And the only way to defeat it is to not give into that fear. In fact, they continue in their sentencing memorandums, the court has, to promote their ideologies and the arguments they made to the jury in their sentencing memorandum, right? Oh, you know, during the entrapment hearing, right? Arguments that the jury and this court in the entrapment hearing didn't buy. That they claim to be these victims in this like government sponsored conspiracy, you know, political prisoners who were found guilty, you know, by a government penalizing free speech. You know, they pushed that conspiracy throughout the course of this on journalists, on media personalities, and even some lawmakers. And some of those people echoed those conspiracy theories. And even here today, they're continuing to promote it. Paul Bellar's whole sentencing memo and Mr. Kirkpatrick's many arguments so far this morning are all about how he's not even guilty, even though the jury already decided that point. The memo didn't address things like, you know, sentencing guidelines, scoring, no, none of that. And he dropped another one on me this morning about why his client's not guilty. They didn't list out all that stuff. It's continuing that ideology. You know, Pete Musico stated in his pre-sentence report that the court has, that he just found himself in these crazy times. You know, he didn't do anything wrong here. He just knew some people, you know, because they claim that nothing really happened here. I think that's the core of their argument. No violent act occurred, so nothing really happened here. They were just overzealous talkers. You know, they found themselves in these crazy, unprecedented times. They were victims, essentially, right? That's the core of their argument. The violent act, Judge, didn't occur because the people that are sworn to protect us, law enforcement, stopped it from happening. That's why a violent act didn't occur. There is no personal responsibility by any of these defendants. Their whole core concept of self is about how the government is responsible for their misery. Selfish, desperate, and it's egotistical. At this point, Judge, in December of 2020 here, more than 2 years after they're arrested, 4 people in the federal system have been convicted for a plot to kidnap the governor by juries or by pleas. 2 of those 4 people were full-fledged Wolverine Watchman members. 3 more stand before you today. And last week, I got a ruling up in Antrim County. 5 more supporters of the plot were just ordered to proceed to trial after we presented a week of testimony about all the evidence we have in that case. That's a separate case, Judge. Their conduct, even though there was no ultimate terrorist act that occurred, their conduct itself had real consequences for real people. There are good public servants, people who want to be public servants, solid candidates, who are never going to seek office because they don't want to be the object of a conspiracy to kidnap them. There are, the governor of the state of Michigan has given her impact statement. She talks about, how it's okay for people to disagree with her, and she carefully thinks about the last thing she says before she parts from someone, right? She worries about the safety of her security detail, her family, right? And I think what stood out to me most about this case is really what stood out to me most about this was that the gang discussed and dehumanized their target so frequently. Our governor, a woman they said that they despised. Chats I reviewed, probably never forget, where the governor was discussed with such in a vulgar, degrading, and insulting terms. And it leads me to believe, Judge, that it's not just that they didn't want anyone to tell them what to do, but that they didn't want her telling them what to do. And it's hard for people, I think it's hard for people to think about public officials as people, as like humans. I work, Judge, in the Department of Attorney General. I had a hate crimes unit, hate crimes and domestic terrorism, and I review death threats to public officials, different ones, like every single day as part of my job. And I've heard so many people tell me that it's just part of the job to hold public office to get death threats, and it shouldn't be that way. And the First Amendment, is in place so people are allowed and protected to disagree with their elected officials, and they should do so. And if you don't agree with those elected officials, you should vote them out. It's expected and it's healthy for a democracy to have the First Amendment. But death threats should not be a part of the job. Politicians, it's hard to remember this, but they're people. They're people with families, with small children, people whose kids live reading the internet and hearing those things and seeing those things. And in today's America, Judge, if you're a politician, your husband can get attacked by an intruder in your home who's looking to try to kill you with a hammer.
I would
because they
object. What
disagree
relevance
with
does
your
that have to this?
policies.
Hold on.
case?
Keep going.
That's today's America. And in today's America, you can get shot at a baseball game because you're playing with the team and someone disagrees with your, policies and your votes in the legislature. And in today's America, like we just saw, you can sign up to be a poll worker, to work an election, and get death threats for volunteering your time to make sure that democracy works. That's where we are, and that should not be part of the job. And frankly, I think we're at sort of a perilous point in our nation's history. I think America is better than this, but January 6th, it didn't happen in a vacuum. The actions these defendants, all 3 of these defendants participated in at the Capitol, our Michigan Capitol, on April 30th, 2020, it was a dress rehearsal for the violence that occurred at the nation's Capitol on January 6th, 2021. It was normalized, their behavior on April 30th was normalized by commentators and even some politicians. What you remember when Lieutenant Green got up on the stand and testified in this case? He was there that day, and he described it in our trial as bordering on anarchy, and that it was like a 55-gallon drum of gasoline, and the people in the rotunda were holding the match. That is not normal. It's not a merry band of patriots coming to see their government at work. It's not political speech. It's intimidation of politicians. And it's threats of violence by armed individuals to prove a political point. January 6th couldn't have happened, Judge, but for the normalization of what these defendants did at the Michigan Capitol on that day. But I do think America is better than this, Judge. And it's not like their behavior, though, is just talk or some pictures in front of a door that went viral. Their gang on multiple occasions, Judge, were itching for a shootout with law enforcement. You know, law enforcement, it's not just politicians, officers whose families live every single day with the idea that their loved one might not come home at the end of their shift. You know, the police at the Capitol, the police in the governor's security detail, the police at any of the protests. You know, when Paul Bellar deployed his QRF, quick reaction force, and Morrison led from afar, asking for sit reps all night. When Paul Bellar put on his body armor and took his rifle and his sidearm and took more ammunition to that Home Depot for some gun part sale that he believed was illegal, he took more ammunition than our CHS Dan, who testified. Dan testified that he took less ammunition to the green zone in Iraq to defend it, right? He did that because he wanted to kill feds. And he said so afterwards, right? It was the police that they hated just as much as the governor, if not more, exhibit after exhibit. And these men that participated in the QRFs, that even structured it or led from afar, who weren't even there, they used the excuse that they were helping people. These men who did not live in the areas that they were traveling to, right, who were essentially outside agitators, they were coming into cities, mixing with peaceful protesters who actually had real issues to solve and were protesting about. They weren't helping anyone. These QRFs, they weren't protecting anyone. These men, all three of these men, ran essentially a terrorist training camp in Jackson County. They brought men from as far away as Grand Rapids and other parts of Michigan to run a terrorist training camp in Jackson County. And the goal of the terrorist training camp, like Pete Musico said in the recording that we have and played for this court and the jury, they wanted to bring Fallujah to the United States. Like, think about that. Guerrilla warfare, hand-to-hand combat in the streets of Jackson County, in the streets of the state, in the streets of this nation. That was their goal. And they did more than just talk about it, Judge. They used operational security, you know, so they wouldn't be detected. They set up a network with others around the country. And their gang, Wolverine Watchmen, their brand, that notoriety, that's what drew other terrorists to them. And that's what drew them to be connected with Adam Fox and Barry Croft. You know, and I told you about this chart earlier, Judge, with this thing. They were at the top of that food chain. These three defendants, they were the founders, the administrators, and the rule setters of this gang. They planted the seed. One of them, you know, preached operational security. They vetted prospective members. They figured out how to recruit. They disseminated propaganda. And they knowingly united terrorists for a common goal. And because of that joint effort, Judge, we believe they deserve the same sentence, the same amount of time imposed by this court, because it's impossible to separate the culpability of one defendant from another in this case. That's our position. You know, Michigan, like I said, and we talked about earlier, I mentioned, you know, we have these really unique state level anti-terrorism laws that criminalize the buildup of a terrorist attack. And the sentence this court imposes sets precedent. You know, Michigan in this case are a leader in this space, and the defendant's sentence, their sentence should be commensurate with setting a precedent. And one of the goals of sentencing that the court knows, deterring others from providing material support to terrorists. It should show that the buildup to a terrorist attack will be taken seriously as an attack, Judge. And here's what's interesting. It's how aiding and abetting in this state actually works, right? Even if a person doesn't actually pull the trigger themselves or doesn't have the guts to pull the trigger themselves, they are just as guilty as the person that they are helping if they are helping that person. That's how aiding and abetting works. That's what we're asking this court to do. I just want to offer one final thought before I sit down and court imposes the sentence and allows the other defendants to talk. We want to thank the court. We want to thank the jury. We want to thank law enforcement, FBI, and MSP. They all had an important contribution in recognizing the threat here and ensuring the safety of the people of the state of Michigan. We want to ask that citizens in the state who see something like what Dan saw, things that happen in chat rooms or online that are concerning, to bring that information to law enforcement like Dan did. It was Dan's immediate reporting, I think, and the information he passed to law enforcement and his actions, brave actions, really, that prevented violence in this case time and time again over the course of several months. He told us about how he served his country, our country here in the military, but I think his sacrifice really continued even after he came home and he signed up to be a confidential human source in this case. The Wolverine Watchmen repeatedly, and I've put in many exhibits about this, they misappropriated the word patriot all the time for a really unpatriotic objective, killing fellow Americans. But really, I think throughout the course of this trial, I think I realized that Dan is what really a patriot is. And that's what we should all try to be doing. Judge, the PSI, it referenced the consecutive sentencing, it referenced the guidelines, we agree with them. And it states that, the gang charge can be stacked, and we are asking that it does. Final thought, I thank the court and I ask the court to send a message, strong message with this sentence. And we're requesting the top thirds of the guidelines on each of the charge consecutively imposed and consecutive to the 2 years on the mandatory felony firearm. Thank you, Judge.
Want to stand up? Passing sentence on you, I'm individualizing your sentence. I'm taking into account a number of factors. I'm considering punishment, rehabilitation, prospects, deterrence, protection of society. I will tell you that Mr. Musico, one of the statements that I heard during this trial, I thought was very telling about your thought process, how you viewed things. And when it was Trooper Rachel Ramey, who was in charge, I believe, of the Marine Reservist, was talking with Joe Morrison, learned that the two of you were trying to get a chimney sweeping business going. And she offers to help you in any way she can, and that included financial help. Then, when you see her up at the protest in Lansing, you walk up to her and look at her and say, I don't care if you are a effing Marine, I'm going to effing kill you. Those comments alone give me an idea of your thought processes. Count one, gang membership. $5 to 20 years, 0 days credit. Count two, material support for terrorist acts. 5 to 20 years. Count three, felony firearm, 2 years flat, 73 days credit. All sentences will run consecutive to each other. It's my obligation to advise you. You're entitled to appellate review of your conviction and sentence. If you're financially unable to retain an attorney to represent you, the court system will appoint one for you on appeal. Request for court-appointed attorney must be made within 42 days of this date.
Costs.
Pardon?
Costs.
All costs, yes, there was 500. 100 fines, and the rest were standard.
Okay.
Deputy, can you remove Mr. Musico?
Have his file, please, Judge.
Do you want the files or do you want me to just give you your sheets and file?
No, I haven't taken out.
Here's Mr. Morrison's and where Mr. Morrison's PSI.
Okay. Ballard, anything further before I impose sentence?
Yes, Your Honor, thank you. And just for clarity's sake, for the record keeping, removing the 10 points does drop the OVs from 70 to 60, but we agree it does not change the guidelines in any way. They remain consistent at 51 to 85. Your Honor, some of the things that I want to mention, and I did present the court with a sentencing memorandum, but I will echo a few things that have previously been noted. In the needs assessment, again, done by the Department of Corrections, on Mr. Morrison, out of the 11, only one is probable, one is highly probable, and the rest are listed as unlikely. That is a significant issue when one considers the people's position in their sentencing memorandum said, my client is incapable of changing his thought. He is incapable of rehabilitation in this matter. Your Honor, this is a young man, 28 at this time. The court has undoubtedly seen multiple sentencing issues and multiple times the raising of a person not even being fully formed until their mid-20s when this was taking place. I fully understand that Mr. Morrison, was involved in this group. We made no argument even in regards to the terrorism scoring or the leadership. He did create this, but I take serious issue with Ms. Dottamani citing that he has taken no responsibility for his actions. I don't know what responsibility she wants him to assert. He was never given a plea offer in this case to step forward and say, yes, I accept, I did this, that. No, nothing was tendered. There was absolutely no reason not to take this immediately to trial as it was taken. So whether or not he is accepting responsibility and he has a statement to make, remains to be seen. But at his age, given his development, and I will cite to the court on page 1 of the evaluation and plan, which is page 3 of it, paragraph 3 lists a whole host of a myriad, if you will, of issues that Mr. Morrison has endured over the course of his life. Not to mention, starting from a fetal alcohol syndrome issue, which is developmentally a problem. He fell into what he did. He is going to, and I anticipate, make a statement where he accepts the responsibility for some of this that Ms. Dottamani is looking for. But I do not believe in any way, shape, or form that a man at 28 years old, having endured what he's gone through, having gone through what this trial and everything has brought to this court, is incapable of understanding, rehabilitating, grasping what has taken place. I don't think that this, and I don't want to give fuel to this that, we're saying nothing happened. What I want to give fuel to is some of what was said, some of what was presented in facts and evidence, some of the testimony that was given, right? If people want to get together and say horrible, rotten things about an elected official, be it the president, be it the governor, be it whatever, be it law enforcement, if they're talking within a group of people, I don't know that the First Amendment disallows that. If someone wishes to say, you know what, I hate this person, I think X, Y, and Z of this person, that is their right. And I disagree with this somehow undermines democracy. Some of the issues that have taken place, absolutely. Within this country, it is as divided as I think it's probably been maybe since the 60s, right? Or even going back into the 1860s if you want. But the ability to be mad is okay. We want to talk about the events at the Capitol in April. Again, they were all legal, right? If the lieutenant wants to get up here and say, well, it was a tinderbox or a 50-gallon drum of gasoline waiting for a match, then something needed to be changed, right? But it wasn't these three individuals alone that were there. I believe the testimony was that there were several hundred people there. They were making their anger and their frustration known. Whether or not they should have taken guns, that's a separate issue, because at the time they took them, it was legal. I don't believe that that was the precursor for what took place on January 6th. They sat back and, again, there were thousands of people involved in January 6th, and I don't think they were that focused on what was going on in Lansing, Michigan at that time. That's just an overgeneralization, an overstatement to say that everybody got together and went, well, they did this in Michigan, let's run to DC. That's a bit much, Your Honor. They want to make an issue out of what took place with some of these people. If Mr. Morrison was trying to evade or use operational security or be somehow disrespectful, I don't know that he would have taken his father-in-law and said, hey, come meet Rachel Rainey, which is what he did, Mr. Morrison, at the Capitol. He introduced his gunnery sergeant to his father-in-law. Hi, this is who is it. Again, there's not a level of disrespect there. There is a acknowledgement. If they're trying to hide out, then surely they're going to say, oh, that's her, let's go the other way. That's not what took place. The testimony was that he introduced her to his father-in-law, separate from the issue that the court noted with Mr. Musico. So again, I don't think that a sentence, especially a consecutive sentence, is necessary reaching the four prongs of the sentencing guideline: to deter, to protect society, to punish. He accepts and is ready to do his punishment. But as the pre-sentence report notes, he actually technically qualifies for the special alternative incarceration. Now, in my memo, and I'm sure the court read it, I asked for that, because if probation is going to say, if he's sentenced in accordance to this is what he qualifies for. Well, if this is what the sentencing guidelines and directives, based on his compass needs, based on what he's gone through, based on whatever developmental challenges they vetted out, and they say, you know what, this might not be a bad alternative, I'm again forced to say, maybe that's not a bad alternative for him, because he is at a point in his life, husband, father, brand new father, who has communicated to me a complete understanding of what life is unfolding for him. And I don't believe that a consecutive sentence, first off, is in anyone's best interest in here. I don't know that it sends the message to someone in California to stop this, or someone in Arizona to stop that. They're not going to see it that way. Mr. Morrison's ready to accept his responsibility. He's ready to accept his punishment. But I would cite, Your Honor, I don't believe he is in a position where he is unable to be rehabilitated. And certainly, again, he was gainfully employed prior to, he was gainfully employed in between during the inception, once he was released on bond until this case went to trial. He has the ability to re-enter and be public, be productive within public society. And I'm going to ask the court simply to sentence him within regards to that. And I believe Mr. Morrison now wishes to make a statement to the court.
Mr. Morrison.
Good morning, Your Honor. Thank you for the opportunity to address the court. I would first like to start with renouncing, disavowing, and detesting everything, the Boogaloo, the Liberty Movement, all those ideologies, all of them, and the Wolverine Watchman. And I sincerely regret ever allowing myself to have any affiliation with people that had those kind of ideas, especially Mr. Fox, who I do believe is a danger to society. And I regret that I ever let hate fear and anger into my heart the way I did, Your Honor. And, the last 2 years, you've heard me called things like Osama bin Laden and Lee Harvey Oswald, and you've heard the names Boogaloo Bunyan and Boob Daddy Bunyan, but my daughter calls me Pizza Buddy. My niece calls me Joey Bear. My wife calls me Babe. My brothers in my Bible study just call me Brother Joe, and all my friends just call me Joe. Your Honor, I'm not the boogeyman that the prosecution is trying to claim that I am. I'm a father. I'm a husband. I'm a friend and a neighbor. I made mistakes. I acted recklessly and carelessly with my words. I got around the wrong people. I fed off their energy. And as to the not being able to rehabilitate, Your Honor, I would say that's absolutely not true, because over the past 2 years, I've truly come to an actual true and trusting faith in my Lord and Savior Jesus Christ. And I had to battle with myself and the Lord, and had to learn how to love my enemies, pursue peace with all men. And as Romans 13:1 says, let every soul be subject unto the higher powers, for there is no power but of God, the powers that be ordained by God. With that being said, Your Honor, I subject myself to you and ask for mercy upon me and my family. And I send my sincere apology to the governor, to her family, and all law enforcement who were affected by what conspired with this whole thing, the whole conception of Wolverine Watch. If I could, Your Honor, I'd take it all back. I thank you for your time.
Mr. Adamani, have you got any comments?
Nothing in addition to what I previously said. Thank you, Judge.
Okay, passing sentence on you. I'm individualizing your sentence. I'm taking into account a number of factors. I'm considering punishment, rehabilitation prospects, deterrence, protection of society. Mr. Morrison, when you got pulled over, you had a gun in the vehicle. You were charged with carrying a concealed weapon in an automobile. It got pled down to about the most basic misdemeanor they could give you. After that event, I believe it took you 5 days to conceive of the Wolverine Watchman. Commander in the Wolverine Watchman had contact with Adam Fox. Involved with militias at the national level. And I understand what you said here today, and I am taking that into account. But hindsight is always 20/20. You got count 1, 4 to 20 years, 0 days credit. Count 2, four to 20 years, 0 days credit. Felony firearm, 2 years flat, 489 days credit. Sentences will run consecutively. My obligation to advise you, you're entitled to appellate review of your conviction and sentence. If you're financially unable to retain an attorney to represent you, the court system will appoint one for you on appeal. Request for court-appointed attorney must be made within 42 days of this date.
Your Honor, for the record, I will acknowledge my client is in receipt of his appellate rights.
Costs.
Thank you, Your Honor. I believe that concludes this matter.
Bellar,
One moment.
come on up.
No, it doesn't.
Thank you.
without going into detail because I wasn't going to ask the court. And I think my client is entitled to have to the pre-sentence report his position. The parole board or whomever looks at it will take it or leave it, but I believe those are facts and evidence, and I believe they're.
I'll listen to you and I'll have it admitted as an exhibit.
Your Honor, first I'd like to start off by saying I don't disagree with what Ms. Dottamani just said in her allocution. I don't disagree with any as it pertains to violence in this country, as it pertains to the January 6th insurrection. My client doesn't agree with the January 6th insurrection. And I think it's clear, Your Honor, when they were in the Capitol, if they wanted to do those things, on those things. They didn't do those things. I also want the record to be clear. Ms. Dottamani had made a statement that Mr. Bellar has not taken responsibility for his actions or anything along those lines. All these arguments up to this point have been my arguments, my legal arguments on how the facts of this case relate to the jury instructions, relate to the elements of the crime. These are not Mr. Bellar's arguments. These are me as his attorney making these arguments. And Your Honor, the reason why I did the pre-sentence memorandum, the reason why I put in there what I believe to be issues in this case is because I was asking and going to ask the court to individualize the sentence as it pertains to Mr. Bellar. In the pre-sentence report that I provided, there was 20 plus letters from individuals that
I had
Mr.
almost
Bellar.
25 letters.
25 letters.
I know because I read every one of them.
And the courtroom is full of his family, his supporters, and people in his life. I think I've got to know Mr. Bellar over the last 2.5 years, believe me, or 2 years.
I'll tell you, Mr. Kirkpatrick, what I read in the letters is nothing compared to they don't match up with what I've seen found guilty of.
And I'm kicking myself every day for not having him testify in this trial. And I'll say that on the record. He and I had the discussion. We decided not to because, quite frankly, I thought I won this case. So I don't have a problem putting that on the record at all.
Sure.
Your Honor, when you look at, and I'll dovetail on Mr. Johnson's arguments, when you look at the sentencing guidelines, you look at the sentencing class B offensives. The only reason that Mr. Bellar scores on the PRVs is because of the concurrent conviction. That's it. He has 0 misdemeanors, 0 felonies, 0 criminal history as a juvenile. He was a valid CPL holder at the time that this offense took place. He had broken no laws up to that point, Your Honor. And the reason why I point that out to you, I think it's important, is because if we don't have the concurrent conviction for the providing material support of terrorist act and the gang membership, we don't have the 10 points. If we don't have the 10 points on that, his guideline range goes from 51 to 85 months all the way down to 24 to 40 months. So from 51 to 85 all the way down to 24 to 40, that's the difference in the guideline range. And now the people are asking this honorable court to sentence him consecutive based upon the conviction for the material support of a terrorist act and for the gang membership. The problem is, Your Honor, he's already being punished for that concurrent conviction. He's already getting a consecutive sentence, in essence, if you do the math. He's getting a consecutive sentence because as a result of being convicted by both crimes, his guidelines double. If it wasn't for PRV 7, his guidelines would be 24 to 40. And Your Honor, the people did a sentencing memorandum to the court as well. I think they hit the nail on the head when they cited the case law regarding consecutive sentences. And Your Honor, it's People v. Northfleet 317, Mishap 649, and it was cited in their brief. And it states the court, regarding the consecutive sentencings, when a statute grants a trial court discretion to impose, this isn't what it says, this is out of their brief, Your Honor. When a statute grants a trial court discretion to impose consecutive sentences, the trial court's decision to do so is reviewed for an abuse of discretion, i.e. whether the court's decision was, quote, outside the range of reasonable and principled outcomes, quote. The trial court imposing one or more discretionary consecutive sentences, quote, are required to articulate on the record the reasons for each consecutive sentence imposed, so the appellate court can review those discretionary decisions for abuse of discretion. More importantly, Your Honor, they go on to say, and this is the case law, Michigan has a clear preference for concurrent sentencing. Imposition of a consecutive sentence is strong medicine. It should be reserved for those situations in which so drastic a deviation from the norm is justified. Your Honor, the reason why I gave you that 10-page sentencing memorandum and the reason why I went through the facts of this case, because I know this case inside and out, is to show Mr. Bellar's actions as it pertains to the charges in this case. I was a police officer for 7 years. He and I have had numerous discussions regarding the statements he made regarding police officers, regarding statements of, as the court's probably going to allude to in your sentencing, at the Home Depot QRF where he wished he was a Fed, at the QRF in Detroit where he said, if they go lethal, I'm going lethal. Some other comments that he made. Your Honor, this court is aware they initially tried to bind this case over for terrorist threats. Judge Claren denied it. They furthered that argument before this honorable court, asking this honorable court to reinstate the terrorist threat charge. This court denied it. I don't deny what Mr. Bellar. Why do you think in my voir dire I spent how long saying, listen, you're not going to like Mr. Bellar. You're not going to like the things that he said. But in this case, can you please promise me you'll disassociate yourself from the things that he said and the things that he actually did? And will you please hold the prosecutor to their burden of proof beyond a reasonable doubt on each and every element of material support of a terrorist act? They all promised me. The jury has spoken, Your Honor. This isn't appellate court, and I'm going to move past that here in just a second. But that's why I needed the court to recall, as I know the court did, what was his actions. This case revolves around Adam Fox, plain and simple. This case revolves around the plot to kidnap the governor. That is the terrorist act. But for that act, but for that event, we would not be here. He would not be on trial for what he said in the Home Depot parking lot. He would not be on trial for what he said or did at the Black Lives Matter protest and the protest in Flint. He would not be on trial for any of those things. Why? Because it was undisputed that he had broken no laws. Yes, he said things that are absolutely should not be accepted. He said things that should cause people to be concerned, but he didn't act on any of them. And I sometimes I feel like I'm talking to the wall, not this court. And I didn't mean it you, that you're the wall. I keep looking at this case over and over and over and over again. He doesn't bring Adam Fox to this group. He doesn't invite Adam Fox to this group. He's not a part of the phone conversation to bring Adam Fox to this group. He goes to the first protest on the 18th. He's not engaged in any conversations with Adam Fox. He's not engaged in any agreement to storm the Capitol or do anything. He goes to the vac shack, not set up by Mr. Bellar, set up by informant Dan. At that meeting, they don't talk about kidnapping the governor, Your Honor. That is just false. They don't talk about doing a citizen's arrest either. That is just false because that would be kidnapping. He, Mr. Bellar, talks about getting a valid arrest warrant. Would it have happened? No. In his mind, does he know that? He's not a legal scholar, but he never one time said anything about kidnapping the governor. Next is the training on June 28th. Does Mr. Bellar invite Adam Fox to that training? No. Does he engage in training on the 28th? Yes. Is there facts and evidence exactly what Mr. Bellar did for that training with Adam Fox on the 28th? No. And at the conclusion of that training, which I think everyone has said on more than one occasion, that is in fact the material support, the training of Adam Fox, which ultimately gets us where we are with this material support of a terrorist act. At the conclusion of that, which again, the prosecutor, and that's one of my arguments for the pre, is they say that before the training, there was an ultimatum given, either you're down with political violence, you're down with this, or you need to leave. We went through that at trial, the court recalls, and how long did it take me? Finally, it happened afterwards. And what does my client do? He leaves. Then we have the July 7th. He forms his own group. We're not aggressors in the state of Michigan. That's his own words, Your Honor. We are training defensively, not offensively. That's his own words. We are not about fucking black bagging politicians. That's his own words. And that is his words after he left the Wolverine Watchmen on June 28th, after they gave an ultimatum and he said, I'm out. He does go to training with Adam Fox. Again, I know I'm beating a dead horse, Your Honor, but it's just so important that there's no facts and evidence that my client was ever a part of the plan to kidnap the governor. No facts. In fact, in my pre-sentence memorandum, I challenged the prosecutor to reallocate after I'm done and give me one shred of evidence that my client was a part of the planning to kidnap the governor of the state, or was part of the training to kidnap the governor of the state, or part of the preparation, or part of the idea even. It wasn't. And on July 29th, he left the state of Michigan for good. Now, court brought up that he did start another group down there. That he was training. And my argument to that, Your Honor, would be for here today, the group, while it's not facts and evidence, the group that he was creating in South Carolina is the very group that he created on July 7th in the state of Michigan that was going to be defensive and trained in case they had to defend themselves or defend someone else. Why would he switch gears from his mentality and his mission statement on July 7th to go into South Carolina to start another group to now wanting to kidnap politicians when he had a golden opportunity right here in the state of Michigan? He had a golden opportunity to link up with Adam Fox, go up north to train and to be a part of this. He rejected it. You can argue all day about the crazy. Your Honor, I argue these things to you because I want you first and foremost to know that Mr. Bellar is not the man that's been portrayed in this court. I firmly believe that. More importantly, he does not agree with a lot of what the prosecutor's allocution was. Her allocution was basically all the bad things that are happening in the country. Nobody agrees with that. I don't agree with that. My client doesn't agree with that. He never engaged in any type of that behavior. He made statements, but he never engaged. He had opportunities, more than ample opportunities to do so. I just can't get over the guideline change from the 10 points because of the 51 to 85. It would be 24 to 40. Your Honor, based upon your knowledge of this case, based upon my consent memorandum, based upon my further rebuttal to the agent's description of this offense, I'm asking the court to sentence Mr. Bellar on the low end of the guidelines. I'm also asking the court to find that this particular, as it pertains to my client, Mr. Bellar, that this is not such a drastic deviation from the norm, and this case is justified. I ask that the court sentence Mr. Bellar for what he did, not for what he said. If we were here for terrorist threats, I'd have a different argument on that, but we're not. And I would ask that the court impose a fair and appropriate sentence based upon his actual actions in this case. And I would ask that the court run those concurrent with each other, with the exception of the felony firearm, which mandatorily has to run consecutive. The only other thing, Your Honor, is my client advised me that he, and he will be speaking here in just a minute. My client advised me regarding the jail credit. He actually was arrested in South Carolina on October 7th. He was in custody throughout. He was transported back to Michigan. So he should get an additional 12 days. Oh, and I'm sorry, one other thing. I know that both brother counsel, Mr. Johnson and Mr. Ballard, talked about the needs assessment in this case. It's in the pre-sentence report. It's on page 3. Out of all of those 11, my client has probable, not very probable, not mostly probable. He has one probable, and every other assessment for Mr. Bellar is unlikely. So I would just ask the court sentence at the low end of the guidelines and run them concurrent and consecutive to the felony firearm, Your Honor. Thank you.
Bellar?
Morning, Your Honor. I would first like to start off with apologizing for the highly inappropriate comments that I made in the past. It does not represent the man that I am today. I have a lot of regret, but as you said before earlier, you always have 20/20 vision from the things you did in the past. So I know I can't do much to change that. I was caught up highly in the moment. I felt I lost a lot of camaraderie after being discharged from the Army. That was the reason I joined the Wolverine Watchmen in the first place. After seeing the direction it was heading, that's when I hightailed it south and I used a girl as an excuse in order to get out of there. I was, to be frank, scared of those guys down there. I would like to, first off, I would like to apologize to the governor. Again, the very stupid comments I made. I in no way meant her any harm. And if I had known about the plot actually being a serious thing, I wouldn't have been where I was at that time. Sorry, I'm not a good public speaker. I would like to thank my friends and family for being here to support me. And I would also like to make a formal apology to them as well. Is it okay if I turn around, Your Honor, and apologize?
Absolutely.
I wish I would have grown up faster.
Always welcome home.
I would like to also thank you guys for the letters. Thank you very much. Thank you, Your Honor, for reading all those letters. I know that was a lot. I read them myself and I was tearing up. I never get to see what people see about me and think about me. I've always heard the demonized version of myself. I would like to accept whatever punishment is placed upon me today. I would also like to thank Kirkpatrick for being here. I couldn't have asked for a better attorney, and I'm really hoping that these charges get ran concurrent so I can sooner get back to the support system, and so that hopefully down the road I can try to find a way to clear my record or my name or expunge this so I can still pursue medical schooling in order to become a paramedic. That is still my goal. That's still my dream, Your Honor. It always will be. Thank you for letting me speak, sir.
Mr. Adamani.
Thank you, Judge. I just have a couple of things quickly to address here. You know, we're not here, counsel correctly noted, for communicating terroristic threat charges, right? So inappropriate comments or comments that should cause people to be concerned is not why we're here. We're here because of actions. And I would ask the court to recall that Dan, when he testified that the most concerning person that he was
dangerous, I believe.
Most dangerous and concerning person out of the group was Mr. Bellar, and he stayed extra close to Mr. Bellar on the day they went to the Capitol. And we're not just talking about inappropriate comments, Judge, or concerning comments. We're talking about comments, and these are all admitted evidence. Mr. Bellar recorded, right, his voice saying things like, "I hope the cops put their back plates in tonight," you know, because he wanted to shoot cops in the back. I was kind of, after the gun sale at the Home Depot, I was kind of hoping he was a Fed. Is it bad that I was kind of hoping he was a Fed? That day, this is in writing, that day your friends realized that you're down to kill tyrants. That was the caption under a photograph of him dressed in full kit, body armor, long guns, sidearm, and extra ammunition magazines in the rotunda of the Capitol. I swear to God, I'm going to fucking Molotov her house in reference to throwing a Molotov cocktail in the governor's house because he was mad at her pandemic restrictions. These are not just inappropriate comments. They're not just, you know, statements that should be concerning. The second thing I want to address is, you know, that Mr. Bellar was not part of the planning, as counsel has said, right? I challenged the prosecutor to show me where he was not part of the planning. You know, he didn't invite Mr. Fox to this group. He did not invite Mr. Fox to this group. The testimony never said that. But here's the thing. He saw Mr. Fox in person more times than Joe Morrison or Pete Musico. He was the one that saw Mr. Fox more times in person than anybody else. He knew everything that Mr. Fox was about. You think that when he's in person with Mr. Fox tones it down from the videos that we saw? He doesn't, Judge. He was completely on brand each time, and Paul Bellar witnessed that. He knew that Adam Fox was serious about doing political violence, and he trained him anyways afterwards. Judge, that's all I have.
Your Honor, may I
Thank you.
just briefly?
Absolutely, go ahead.
Your Honor, that's precisely why, as part of my pre-sentence memorandum, I attached exhibit number 2. Exhibit number 2, which was exhibit number 10 at the trial, is a 4-page timeline of the contact between Mr. Musico and Mr. Adam Fox, Mr. Morrison and Mr. Adam Fox, Mr. Musico and Barry Croft, Mr. Morrison and Barry Croft. 4 pages. My client has none. Yes, he was with, he was with him at the Capitol on the 18th of June, did nothing. He was with him at the back shack. I've already beat that dead horse. He was with him at the 28th training. I've already beat that dead horse where he left after that training. And he went to the training in Wisconsin. I've already beat that dead horse. And then he leaves the state of Michigan for good on July 29th when the, oh, by the way, informant Dan, working for the FBI, is meeting with Adam Fox, which my client's not there, nor is Morrison, nor is Musico. And the informant Dan and Adam Fox are coming up with a plan to kidnap the governor, not my client. Your Honor, I'm asking the court to sentence him at the low end and not run them concurrent, Your Honor. I can consent.
Okay. Passing sentence on you, I'm individualizing your sentence. I'm taking into account a number of factors and considering punishment, rehabilitation, prospects, deterrence, protection of society. Count 1, 5 to 20 years, 0 days credit. Count 2, 4 to 20 years, 0 days credit. Those 2 sentences will run concurrently. And then you got 2 years with 88 days credit, which will run consecutively to the first 2.
Thank you, Your Honor. Thank you very much.
My obligation to advise you, you're entitled to appellate review of your sentence. If you're unable to retain an attorney to represent you, the court system will appoint one for you on appeal. Request for court appointed attorney within 42 days of the date.
It doesn't matter.
Thank you, Your Honor.
Thank you, Tori.